A very warm welcome to all the dignitaries on and off the dais. Fresh beginning always exists, either to apprise or to surprise. May I now request our chairman of English Literary Club of MMBA, Dr. D. GNANASEKARAN, to give the welcome address.
Honorable Mr. Justice C.V. Karthikeyan, Judge Madras High Court, Mr. S. Srinivasa Raghavan, President of MMBA, Mr. K.P. Narayana Kumar, General Secretary of MMBA, Senior Designated Counsel Mr. Balasundaram, English Literary Club members Mr. HELDON Kumar, Mr. M.S. PARTHIBAN, who is Master of Ceremony here, and Mr. MAHABOOB ATHIFF, who is to make vote of thanks here, executive members of MMBA and members of MMBA, and Mr. Airam Selva Kumar, who on his own accord, without coercion or undue influence, has come forward to fit the bill for the refreshment after the meeting. And members of fraternity, everybody, my grateful good evening to all. Highly privileged and especially honored am I today to have been given this opportunity to welcome Honorable Mr. Justice C.V. Karthikeyan and the learned gathering. Before I welcome Honorable Justice, I have to profusely thank our President Mr. Srinivasa Raghavan, for he had played a pivotal role in having Honorable Justice amidst us here today. I have to be very time conscious. I should not consume time beyond 3 minutes. Within these 3 minutes, I have to complete my welcome address. The topic on which Honorable Justice is to speak today is linguistic evidence, which will help us understand sections 3 and 4 of Evidence Act, section 308 of Criminal Procedure Code, section 19 of PC Act, and section 29 of POCSO Act. It will not be an exaggeration, and you will not mistake me or misconstrue me if I say that Honorable Mr. Justice CVK is a sentinel on qui vive to protect the dignity and decorum of the advocates. Recently, our Honorable Justice has rendered a judgment titled V. Ayyadurai versus State of Tamil Nadu. It is a common order for 3 writ petitions. Honorable Justice reserved the judgment on 1/3/2023, pronounced the judgment on 3/3/2023. It pertains to setting aside of a GO that puts a ceiling on the fee for the government advocates. The judgment runs 638 pages in 66 paragraphs. From paragraphs 45 to 52, it describes, visualizes, picturizes the activities of an advocate in the chamber as well as in the court. If you permit me, I would like to read only 2 paragraphs. Paragraph 45. The profession of law is a complicated profession. Legal acumen is required in consultation with the clients, in preparing pre-suit notices, in preparing any other representations or petitions, in preparing and drafting a plaint to be presented before the court, in preparing the documents to be filed, and if appearing for the respondents, in preparing the return statement or the response to the claim, and also preparing counter to all applications filed. Thus, next succeeding paragraphs describes the activities of the advocate. And paragraph 50, it is owing to the acumen to legal language and on the various facts of each case that the profession is also called a learned profession. Knowledge should expand beyond facts. A felt description. Knowledge should expand beyond the facts of the case. To also know the laws of the land, the precedent set by the courts. And paragraph 51 contains only one sentence. The one sentence speaks volumes. The one sentence is this: there must also be skills in advancing arguments, and in thinking on the feet. This is the particular words that made me very humble, because it reminds me of the solitary reaper, authored by William Wordsworth. Behold her, single in the field. Like that goes on, reaping and singing by herself. The same description has been done with regard to the duties of the advocate in the court. Here. Thus, this judgment or every judgment is fruit of long, hard labor and experience draped in responsibility, and above all, concern for the upliftment of our advocates, the fraternity. Today, we are very happy and fortunate enough to have the lecture from our Lordship, and we shall all reap good dividends. With this, I welcome our Honorable Justice, Mr. C.V. Karthikeyan, on behalf of the English Literary Club, on behalf of the MMBA, and on behalf of the huge gathering. Thank you very much.
Now I request Dr. D. GNANASEKARAN, Chairman of English Literary Club of MMBA, to honor our chief guest with a memento. Thank you, sir. Thank you, Lordship. Today we have our special guest, Honorable Mr. Justice C.V. Karthikeyan, with us. Our Lordship was born as the 6th generation in a family of lawyers and judges. Finished his schooling at Chennai and graduated in BSc Statistics from Madras Christian College, and finished his Bachelor of Law from Dr. Ambedkar Law College, Chennai, and completed his ML from Annamalai University and MA from Madurai Kamaraj University. Our Lordship has enrolled as an advocate in the year 1989 and joined the office of late Sri V.S. Subramanian Advocate. Our Lordship was selected as a district judge in Tamil Nadu State Judicial Service and joined the service in the year 2005 as a district judge in Ramanathapuram, and is elevated as a judge of Madras High Court in the year 2016. Today, we have a very special topic to know and learn, and we have the best and the befitting person to sail us to that topic. May I now request our Honorable Mr. Justice C.V. Karthikeyan to deliver the today's topic, Linguistic Evidence.
A very good evening to all here. Mr. Srinivasa, Raghavan, the President of MMBA, Mr. Narayana, Kumar, the Secretary, senior members, and Dr. D. GNANASEKARAN, the Chairman of English Literary Club, Mr. MAHABOOB ATHIFF, the member of English Literary Club, Mr. M.S. PARTHIBAN, and also Mr. S. Michael HELDON Kumar, member of the English Literary Club. Respected senior members of the bar who have come here this evening, and their advocates, sisters and brothers. I was sitting there wondering about the introduction given, and the thought process goes on and on. We have what is called, there are two types of judges, and when somebody says an introduction, there are wise judges, and you have experience of many of them here who come over from Chennai to Madurai bench, and those who are also permanently in Madurai bench. But when somebody talks, or when somebody comes into the chamber, like the other day, last Monday, when Mr. Srinivasa Raghavan came with the president of the Literary Association, and somebody comes to the chamber, even if to an advocate's chamber a client comes in, we try to we cannot be wise, because suddenly that is a quality which cannot come, but we try to be wise looking judges. So wise judges and wise looking judges. So I was sitting there thinking, okay, let me look wise. I may not be wise, but let me look wise. So put up an air and then say, I am wise. But that has its own limitations, because then you might be thought of being otherwise judge. And that will lead to very serious complications about what everybody will perceive of us. So it is only apt that remain as I am and address all of you. And as a member of the bar, quite passionately I was practicing. and it was never my intention to become a district judge. Wrote the exam to test myself. It was not actually with a view to become a district judge, because there was a good practice going on. And quite honestly, if you look at it salary-wise, till there was a revision in the pay scale of the High Court judges, what salary I was earning 15 years back was equally touching the salary I was earning right through. So there was not any monetary gain if we have to look at it from that narrow angle. I was just testing myself as to whether I could. I wanted to shift over to another state for practicing Delhi. But then the marks came out and they said that I should write. Now, the language itself is quite a strange language. English when applied. When we talk about wise judges and wise-looking judges, the other day, somebody came to my house and said, my daughter is married, but then he said, they have no issues. I was wondering, why is he worried about that? Because all of us know what an issue is. An issue is a point of conflict. When there is an assertion by one side, and when there is a refutal of that assertion by the other side, all of us, you will tell the judge, frame an issue on that. And we are trained to frame issues as trial judges. I was also a trial judge. But the meaning is different. It means there are no children still. But can issue ever be thought of as being a child in the family? Because that is something which is a conflict leading aspect. So this is what is quite a different deep meaning you will have to give when you apply words. If many of you have read, are reading in the habit of scrolling through our internet, Bar and Bench. If you see Bar and Bench, 3 days back, Mr. Arvind Dattar, senior advocate who has his roots in Chennai, Madras, and who is now in Delhi, going on and off. He had written an article about the same word having different meanings in the same section. And he was pointing out to section 14.1 and section 14.2 of the Hindu Succession Act. Now, both of them, section 14 talks about acquisition of properties by a Hindu female. And 14.1 talks about if a female acquired properties. And 14.2 talks about a property acquired through will. So the word acquired in section 14.1, according to Mr. Arvind Dattar, referred to a past tense. A property already acquired by a Hindu female, how is it going to be dealt with? And the word acquired, again the same word, in section 14 subclause 2 is a future acquisition through a will. So he was pointing out this conundrum. The same word used differently in two separate sections. He wrote an article on that, a brief article which caught the eye. So that was what went in my mind when I was called to speak about a particular topic. It could have been very easy for me to have said, all right, let me talk about language and law, and cull out a few phrases from various poems from Shakespeare, or from, as the President said about William Wordsworth, the solitary reaper. He said, somebody who sings and dances alone in the field. Well, if somebody here were to sing and dance alone here, we would only call the hospital, mental hospital, and say, please, there's something wrong with that person. But there was a poem written on it, A Solitary Reaper. It's a wonderful poem. There's one more poem about by William Wordsworth, and that was called Daffodils. That's a wonderful poem, because he says he walked across the field and saw a line of daffodils, daffodil flower. And when we see a thing like that, he said, when you are in a vacant and in pensive mood, that is when you sit round and then not think of nothing, that image of daffodils come to your mind. So he has this wonderful expression. Coming back to the topic, or rather a slight deviation from that, while talking about issues and looking wise and trying to look wise, I was remembered about another anecdote. This is a real anecdote about what happened in the Supreme Court. I don't want to say the name of the judge because the son of that judge is quite well off in the legal field also, and I shouldn't say anything. But the advocate there is somebody whom all of us will know, Mr. G. Ramasamy, a former Attorney General who also had his roots in Tanjavur, moved to Chennai and then moved to Delhi. He was Attorney General, and that is the highest post. And I remember seeing Mr. G. Ramasamy after he retired, after his term as Attorney General got over. And the way he projected was he had this docket. We have the advocate bundle, and he used to print G. Ramasamy, big letters. And next, former, and in huge letters, Attorney General. So he had that pride of that. He was arguing in the Supreme Court. And he's a very forceful advocate. He never gave any inch or never compromised on any issue. So he was quite raising points after points. And the bench there, Supreme Court judges, they are Supreme Court judges, or they are supreme. One of them said, "Mr. Ramasamy, do you think we are fools?" So he said, "That's a very difficult question to answer. If I say yes, then I will be committing contempt because I am calling you all fools. If I say no, I will be committing perjury because I am saying a false thing." So that was the quality. And that is usage of words. That is something thinking on your feet. And that is very essential. And that comes about only with a deep knowledge of the facts and self-confidence. So this is what happens. And he was talking about judgment written by me, and he said it is the product of hard work. So that again set a thought process in my mind, because all of you are quite experienced advocates and you watch judges and you watch how they function. And let me take myself out of the first category, because you would have said, "Oh, he's a very hard-working judge." But there is also another category, hardly working judges. I can say that out of deep personal introspection. So you have hard-working judges, and you also have hardly working judges. You have wise judges and you have wise-looking judges. And there are judges who risk themselves by asking an advocate, "Am I a fool?" So I will have to fit myself in one of those categories. Now, coming back to this topic, and I am doing that with much reluctance because this is a topic which all of you think that I know something about. Actually, I don't. So neither wise nor hardworking, and I am just going to speak something about what I thought is very important. Now, where this topic came in my mind was a real incident when I was sitting on the original side in Madras. Now, that is a very curious side, original side they call it, nothing original about it, because it is before the Madras High Court was even conceptualized. That was trial work done in Madras, the old city of Madras province, and that was done in what was called the Supreme Court. And when the High Court was established, they did not know what to do with that Supreme Court. So they merged it with the High Court and said this is the original side. And so the old Supreme Court became the new original side. And among other works, one application came before me for probate of a will. And there is one more practice there. You have what are called interpreters who are employed in the original side. So originally, when I started practice, during cross-examination, and which sometimes I regret is not being done now, it was done in open court, like how it is done in the district courts. And chief examination was oral, and cross-examination was oral, presided by the High Court judge. And question, interpreter is there and interprets in the language of the witness, gets the answer, tells that in English, and then it is typed. So there's a big process. Question, answer, like that. So one probate matter came where the will was in Hindi. So if any document other than English is presented in court, it has to be translated by these interpreters, and they have to put their seal as if that what is translated is the correct version. But this particular will had been written by a person who gave his property quite roaring business. He was a North Indian, Marwadi, and therefore he had this pawnbroking business and everything. He had given everything to the person who applied for probate, who had nothing to do with the family. And he had written it according to the version just before he committed suicide by falling in front of a train. So he's dead. So a will comes into force only after the person is dead. But we always require proof of a will under section 68. And they should be examined, witness must be examined, or under 69, somebody who knows the signature and writing must be examined. But here nothing, he just wrote the will and went and killed himself. That's what the version is. Now this document was used by the police as a latent document, in the sense that a hidden document, to show that, to raise a suspicion whether it was actually suicide or murder. So you get some documents, some evidence, which on the face of it, when you read, that gives a suspicion as to what is the theory behind a crime. So that is where they bring in a term called a linguistic evidence. That is, the language used is a strange language not ordinarily used by that particular person who should have written it, or who is projected to have written it. So this is used, this analysis is used by investigating officers. You have forensic psychology. When young children, young girls or young boys are victims of sexual offense. Saturday, Sunday, I was in Bhopal, and I was giving a lecture to the participants there about vulnerable witnesses and the safeguards to be adopted by courts across the country to protect vulnerable witnesses. Vulnerable witness is somebody who is a victim of sexual offense. Not only that, somebody who cannot express themselves in court, who are having difficulty to speak or difficulty to understand what is happening, those who have special children. So this happens, and when such witnesses come in, when such small children come in as victims, one method used, it is quite a strongly used method, is asking them to draw something in freehand in a paper. And very often that may not be projected before the court during trial, but it will be there in the case diary. They write, they draw as to their experience, as to what they underwent during the sexual offense perpetrated on them. They give a fair image of the person. They give a fair image of what actually he did, where he touched or what he did. That is drawn by them. This is forensic psychology. And this paper, it may not be language as such, but these are some hidden clues for detecting a crime. This is something real. It is being done. I will tell you one more example. I was a director of the Tamil Nadu State Judicial Academy. We have a hall like this, and like all of you, I was sitting there, and like the president and the secretary, we had judges there, and I was a district judge director, and they were there, and like every function, a memento is given, and everybody stands across 1, 2, 3, 4, and then they receive, and then they do it, and everybody claps. But the problem is this: when photograph is taken and later given, one of the judges told me, I was there in the stage, you have not taken me on that photo. I was there, I was standing there, and I was smiling away, and my photo is not here. Go get that photo where I am on the stage. Now where do I get it? I saw all that. He was sitting right there, not on the stage. But he wanted the photo of him on the stage. So what do? We use this forensic thing. There's that person there. Try to find out who bodily is similar to this judge. Cut off that head. Put his head where he's smiling nice there. Bring it there, put the head in that photo and give it to the judge. So this is one hidden aspect which is not easily seen by our naked eyes. Languages are written. Now you also have voice makeovers where the same person stands and states something else with the lip movement they bring it. All these are the new forms of evidences which are used in crime detection. It is being used in India in a large way. It was used long back. And I will tell you one real investigation, and I think many of you might have known it. And then I will come to a certain few sections which the President had said about where linguistic evidence comes in. I do not know whether all of you know about Alavandan murder case. Now, if for those who do not, anybody does not know about that Alavandan murder case. It happened way back in 1952. I do not know whether everybody knows it. Now, what happened was, it has a close connection with Madurai, Sivagangai. It was the old boat express, which was Ceylon Express, the train which runs from Chennai Egmore to Rameshwaram. It comes at such a time that from Rameshwaram, if you go over to the tip point, Dhanushkodi, from there you can catch a boat to go to Sri Lanka. So the timing were maintained the same. It was called the boat mail. In Madurai, right from before that, the passengers complained about a smell coming in from a luggage in the third class compartment. So it was a tin trunk box, the old trunk box. And they stopped the train in Madurai junction. The inspector came and they saw it. When they opened it, they saw a body there, crushed body, without a head. No head. So this is in Madurai. The train started in Madras in Egmore. So they found this. And then they analyzed the body and they could not do anything. And later the message went. See, at that time no phone, nothing. It was just deep investigation of whatever is available. The quality was far better than what it is today. Later, they found a head floating in Royapuram beach, somewhere at the corner. So the police found that, and this was a body which slowly the message went up to Madras, and there they found a head, and there they came to know about a body found in Madurai. And one of the leading forensic doctors, Dr. Gopalakrishnan, was the forensic expert who matched the head with the body. And they found that it belonged to an employee of the Alavandar was an employee of Gem and Company, which is a shop still in existence. It is still in existence. If you come to Madras, if you go opposite High Court, you walk down to NSC Bose Road, you cross Broadway Junction, and you walk further, opposite Flower Bazaar, the old Flower Bazaar, you will find still today Gem and Company. It's a pen shop. And he was an employee there, and the owner of the shop had given a complaint that the wife had given a complaint that the Alavandar had not come home. And then they started investigating. They found that he had a relationship with a married lady who was staying in Cemetery Road in Royapuram, and had gone over to her house, and there the husband was there, and They had apparently murdered him and cut off the head. They recovered the knife and put the body in a trunk, put it in the train. The body came up to Madurai. The head they went and buried in Marina Beach, and because of the waves, the head came up. This is nothing. This is what it is. But where does linguistic come in here? The evidence was that during trial, the trial was in the Madras High Court itself. Sessions trials took place in court number 4 in Madras High Court. That's a strange court, because from the ground floor, you'll find a swirling staircase like this going up, and there will be an opening, and the accused will just pop up into the court. He's not taken across the corridors. That swirling staircase is still there. And in that particular court, instead of the wooden floor, that will be thick glass. So if anybody can come, you can still see that. Third, in the side, Rajamanar Holkar. And the accused will come there. The downstairs you will still find semi-jail, because all the bars will still be there. And instead of the wall like this, the bars will still be there, like a jail. So the trial took place there, and the prosecutor was Govind Swaminathan. He was the crown prosecutor. And during trial, this identification of the body was the main thing. In any case, you should first identify the body. There must be a body and identified. The wife came to court, and there this evidence was pointed out. She stood in the court, and before that she was taken to identify the body. She never said anything. She started crying. And the judge inferred that by that reaction, it can be inferred that it was her husband. No words immediately, nothing but the cry. And it is very nicely described about how she came and cried over the body. And they also brought the knife, and they showed the knife to her, and she started crying more. And that's the end of the evidence. Again, you will find that it is not often spoken words, but reactions and expressions which form a sentence. Now, all this adds up to what is called, and there was a conviction on that. But conviction was only for 7 years. As the judge was Justice A.S. Panchapakeshayar, and he was an ICS person. And he did not give the complete sentence. He said this man deserved to die, and therefore he died, and therefore no sentence, we let them off. And the husband and wife who later got remission built a big hotel in Kerala. So they shifted to Kerala and they stayed there. Now all this points out to looking deeper than what actually is recorded by the police. That is what is something which you have to develop in the modern day world. You are presented with electronic evidence. You are presented with certified copy, Xerox of Xerox. I had also another case where I was asked to look into the screenshot taken of a particular mark sheet. I do not know the propriety of me to state it, but the fact is this. An exam was written, and the allegation by the petitioner was that when they saw the mark sheet, which was put up in the website, it had a different mark. And when they saw the original, it had a different mark. And therefore they said that screenshot should be examined, because that reflected the correct mark, and what was given in original is not the correct mark. We have to do a lot of forensics on that, because if you know about animation, how the cartoon pictures go, you will find the head being put in a block, the arm being put in a block, each part being put in a block. The next frame, it will just move. The block moves. It keeps moving, and that is why it's done. When this mark sheet on the screen is analyzed, it can be easily seen that the bottom portion where the signature is there can be taken out and be replaced by another. The side number which is given can be taken out and be fixed without the main thing being disturbed. So these are all aspects which advocates should know, which goes beyond what we normally call as evidence in court. It is something deeper, and it is there. I would like to touch a few points on sections 3, which is of course on proof, section 4 of may presume, shall presume, and conclusive proof. And let me start with that, and I hope I do not bore you on that, because going back to college. But there are few words which is linguistic, and in Evidence Act the usage of one word differently between these three definitions makes a big difference. If you see section 4, and I think all of you should be thorough on section 4, but let me point out one small aspect on that. On section 3 on proof, because everything depends on proof, presumption and preponderance of evidence. Now what actually is preponderance of evidence? Proof by preponderance of evidence. These three concepts touch upon the interpretation of the language in the Evidence Act itself and in judgments which support this. If you see what proof is, section 3, it can be divided into two parts. I'm not taking a lecture, please forgive me if any of you think of that, but just pointing out one or two words in it. A fact is said to be proved. All of you know that. After considering the matters before it, that whatever is presented before the court, there are two parts. The court believes it to exist. So one is the belief of the court. You cannot question that. No advocate can question it if the court says, I believe this is true because of these records. But the second aspect is, a prudent person, in the circumstances of that particular case, not on the basis of the records, but on the circumstances of the case, ought under the circumstances of that particular case to act upon the supposition that it exists. So there are two aspects. The belief of the judge, or a prudent person, a president for example, should suppose that this is the fact. Now that takes the proof of something beyond what all of us expect. If we see a dead body here and there is a man standing next to it, president will suppose that he committed the murder. But ATHIFF there will say that is not the correct supposition. The body is already there. This person could have just come there and be standing because he did not know there's a body with multiple injuries, and he is standing there. He is not the murderer. Both are possible. This is what you have to understand when the court says, I suppose because of that this is true. Where your cross-examination has to be on that particular witness who says, I suppose this is what happens. Let us take another example. A person is here and the president goes with a small child to the next room. There's a witness. He sees the person carrying a small child and going to the next room. And when he comes back alone. He does not carry the child back. This alone the witness knows. What then we come into the area of supposition. As advocates, will you trust that? The child is not there, and later the child is found murdered there. Now what will be the inference which is to be drawn? That this person should have committed that murder. Normally. But when you come to presumptions, to section 4, you will have three separate presumptions: may presume, shall presume, and conclusive proof. If he gives an explanation, no, I went there with the child, but the uncle of the child came, I handed over the child and came back. How far can we accept that state? That is what section 4 is about. But there is a one word which distinguishes may, shall, and conclusive proof. Just one word. That is what, if you understand, it comes out. If you see section 4, may presume, the Evidence Act says, this is in touching with evidence, whenever it is provided under this act. So may presume is whenever it is provided under this act. In the sattathu kodukapattirukka nerathu. Shall presume, I will read only the three words. Whenever it is directed by this act. The word difference. One, provided under this act. The second is directed under this act. Adutha dharma sollapattirundha. Then it is shall presume. The third one is conclusive proof. When a fact is declared by this act. So you have three separate words. This is what practitioner of law should analyze in the statement of a witness. When it is provided in an act, declared in the act, and directed in the act, and declared in the act. Now I'll give you one example about being declared in the act. And that is an interesting example on section 112 on conclusive proof. Because we have many applications filed. Conclusive proof of birth during marriage and proof of legitimacy. The section says the fact that any person was born during the continuance of a valid marriage. Born during so there are two foundational facts. There must be a marriage, and in those days they said it must be a valid marriage, and during the subsistence of that marriage a person is born. Within 280 days we will leave that. After its dissolution, the mother remaining unmarried, that is one aspect, shall be conclusive proof that he is the legitimate son of that man. So the law says conclusive proof. I use this when applications were filed before the family court to refer the DNA, the child, to test the DNA of the child with the father to test paternity. But the proviso says it is conclusive proof. No evidence can be let in. Now I will come back to section 4. But what is the nature of evidence that can be let in to disprove any may presume or shall presume or conclusive proof? When they say may presume, a fact can be presumed if it is provided. It may either regard such fact as proved. May presume comes in section 114 A, B, C, D, E, F, G. If a document is sought to be directed to be produced, not produced, court may presume that it is not produced because it is adverse to the person, until it is disproved, or may call for proof of it. So there must be proof of to rebut that particular presumption. The level of proof is much more than in other cases. Shall presume is, it shall regard such fact as proved unless and until it is disproved. So the words used are totally different. And conclusive proof is, it is declared and no evidence can be let in as against that which is conclusively proved. All this depends on when you examine a witness under section 313 CRPC. All of you are, if you are trial advocates, what is the portion of evidence which he should rebut, and to what extent should the defense let in evidence? There, if you analyze these three provisions, you will have a better contract of the case. And this is what is evidence all about. The third aspect is preponderance of probabilities. What actually does it mean? Because everywhere it is used, a civil matter is decided on preponderance of probabilities. I will give you one old case. That is the base case for determining what actually preponderance of probabilities is. And that is State of Madras versus Vaidyanatha Iyer, 1958 Supreme Court. If you want the actual, I won't be stating any judgment at all except for two, which I think is required by you. State of Madras versus Vaidyanatha Iyer. Please, when you can have time, AR 1958 Supreme Court, page 61. That judgment is still today relied on by the Supreme Court. Preponderance of probability. It again revolves. When you read the judgment, they only talk about may presume, shall presume, conclusive proof. Nothing else. Every criminal case, even when I sit in criminal appeals, when I sat as a sessions judge, We only look into whether the defense advocate has punctured this particular fact. If a small suspicion is raised, then you get the benefit of an acquittal. And which fact you must attack of the prosecution? One, of course, is the procedure on investigation. If the facts are thorough, you question on the procedure. But if facts are wavering, then which fact to actually? Now, State of Madras versus Vaidyanatha Iyer, they examine in detail as to what actually is preponderance of probabilities. It is about a case of bribery, receiving of bribe amount. He was an income tax official, and he demanded a bribe of rupees 1,000. And the fact that it was demanded was proved. The fact that it was received was proved. That the fact that the amount was tainted money, that is picked up in that phenolphthalein and all that, was proved. The fact that he was an income tax officer and that the person who actually from whom he demanded had a pending income tax return with this officer was proved. Everything is proved. And then that is where you read these judgments because of the ingenuity of the advocates who gave an explanation and insisted that this explanation could have a doubt and could be used as preponderance of probabilities to puncture a hole in the case of the prosecution. What was the explanation? It's an explanation which all of you will come across. He said, my daughter had to get married. I did not have money. I wanted money. I saw this person. I took the loan from him. As a loan, I took the money from him. It's an explanation which not many people will believe, but the development of that explanation during 313 questioning and during explanation given in 313 questioning brought about a result which is astounding. So that is one judgment. This gives you a base on what evidence and how language and evidence has to be analyzed. It all depends on the phraseology of that. This is what they then said. This is linguistic. We have to appreciate that because the original version was in Tamil. And they said that this linguistic we will appreciate, and they gave a judgment. Second judgment, which later if you have time, I would request all of you to read, is again an old judgment. AR 1957 Supreme Court, page 614. Old judgment. Vadivelu Thevar versus State of Madras. I do not know whether anybody has heard about it. And that speaks about witnesses. A reliable witness, a witness who is totally reliable, a witness who is totally unreliable, a witness who is partially reliable and partially unreliable. So they give that distinction. How you can, to what extent you can take the statement of a prosecution witness in a murder case. This was a gruesome murder. It happened close in the southern states. The deceased had a tea shop. At that time, there were no customers. The house was behind the tea shop. So his wife, Bhagyam, she called him inside the house to have his tiffin. So simple, we can imagine that. Just before he was to go there, a customer came asking for tea. So he stayed back in the shop to make tea for the customer. Sada tea kata. It happened in Ramnad. At that time, the accused came. And one of them was standing, the other cut him. The wife came running out. She came running out. He did not die. She put him on her lap and she cried. They both went away. They then realized they had not killed him. So they came back. And then she stood up and she was frightened. She stood up and went out. They again cut him. And then he died. Again one person cut, the other person stood. Evidence what happened when it was committed by the magistrate. He interchanged A1 and A2. The person who actually cut was shown as A2 and the person who stood was given as A1. When the trial went to sessions, it is committal, and then it goes to sessions court. In sessions court, she said the opposite. Who was described as A2, who was she said he only cut, and who was described as A1, she said he was standing. Confusion. So the sessions court said they could not overcome direct evidence, and implication of both the accused. The sessions judge convicted. It went to Supreme Court, and Supreme Court started analyzing, and that is a very good judgment. Please read it, about analysis of evidence, where they talk about 3 types of witnesses and how they express themselves and how much you can accept their evidence. This deep analysis for every case is required, particularly in the life of a person is involved. And they talked, as I said, about 3 separate categories of witnesses. They said, generally speaking, oral testimony in this context may be classified into 3 categories: wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable. Now, and then they started analyzing. What is the nature of proof in the first category? What is the nature of proof in the second category? And what is the nature of proof in the third category? Again, they go back to Section 3, Section 4 of Evidence Act. No further than that. It all revolves around understanding those 2 provisions. Now, those 2 provisions are important because today we have so many cases on the POCSO Act. And under POCSO, there is one strange provision. It is still debated. It is extremely debated. Even anywhere we go, it is debated. And that is Section 29 of presumption. Section 29 is quite strangely worded, and that is why it is debated. And I would like you to also think about it. Section 29 of POCSO Act talks about presumption as to certain offences. Certain offences means offences under that particular POCSO Act. Nothing more than that. So they are offences under Section 3, 5, 7, 9. It says, but the word used, I am only on the word used, where a person is prosecuted for committing or abetting or attempting these offences 3, 5, 7, 9, the special court shall presume that such person has committed or abetted or attempted to commit the offence, as the case may be, unless the contrary is proved. Now what I want to insist on this is, which I have my doubts, and I would like you to think about it as advocates, because you are going to deal with it. You'll be actually dealing this day in and day out. Where I'm not about the presumption, but I am about this. Where a person is prosecuted. Now what does the word prosecuted means? Is it filing of charge sheet? Does prosecution commence? Or taking cognizance of charge sheet? Or framing of charges? Once charges are framed, the person stands prosecuted. It is ongoing. He is being prosecuted for that offence. Now, if charges are framed, can the public prosecutor stand up and say, now he is being prosecuted, this is the charge has been framed, now let him prove to the contrary and then I will prove myself? Does the burden shift totally to the accused? Does the prosecutor just sit down? Because it is not on whom evidence has been let in, and I will let you where evidence is let in. On Prevention of Corruption Act and on Code of Criminal Procedure, on the same aspect where different words are used by the legislature. The normal use of the words prosecuted is, he has been charged. It is not as if evidence is completed. Where prosecution had completed evidence, then presumption comes and then rebuttal starts. That is how it is. 313, incriminating evidence let in by the prosecution is put to the accused. and then he has a chance to explain those incriminating evidence. Here there is no evidence. It is only prosecuted. Now where does this lead us to? Then we have to understand it is only judge-made law, not legislature-made law, where they say even then some foundational facts will have to be established by the prosecution. But that is not the words in the provision. What are the foundational facts? The victim must be a child. There must be evidence that he or she had been sexually assaulted. There must be further evidence. If there is medical evidence to that, medical evidence must be brought in by the prosecution. But these are not words used. Prosecuted alone is used. It is not where a person is prosecuted and evidence had been incriminating evidence had been produced. That word is used in the old framing of the law, where 313 incriminating evidence, whatever is said, is put to the witness. It is not that. It is only prosecuted, then the court shall presume he is the accused. Once I take cognizance, I've been a sessions judge, I have handled POXO cases. Once charge sheet is filed, once I read the charge sheet and I am convinced and I issue process to the accused, and when he comes, I frame charges, I am satisfied. It is for him to explain. Is that the purpose of this particular provision? There has been very little debate on that. And that is what I want to kindle in your minds. This is example of evidence and the literature in the enactment. There is one more factor, and I was talking about the code of criminal procedure. One damaging witness in any offense is the evidence of an approver. He participates in the crime. He very well knows everything about the crime. If it is a crime for gain, he participates in purchasing the weapons. He participates in identifying the victim. He participates in identifying the house, the timing of the victim. He participates in finding out how to enter into the house. He participates in finding out after entering where the deceased is, where the money is, and then if there is a murder for gain, in the murder, in the gain, in taking, and in disbursing the amount, in taking some portion of the amount, he participates in everything. And then he turns approver. Now, this is something which Indian law alone provides, that you can ask one of those who are accused to speak for the prosecution. Indian law provides that. Because they wanted conviction when it was originally felt that natives of this country were always the accused against Europeans or the British. So therefore, to firm that up, they said, brought in a concept of approver. Independently in Evidence Act, you don't have the word approver. You have what is called an accomplice. And the evidence of an accomplice is not a full, completely reliable evidence unless it is corroborated. But approver, if gives an undertaking that he will disclose everything, a judicial order is passed that he can be granted pardon. Nothing happens to him. But he must say what happened. Now that is very damaging for, if you are advocate for the accused, because you will now have not only the prosecution, but somebody who was with your own client right through, who is going to speak about your client as a first-hand information. This is, and later, this is 306, 307. I am not here about the procedure for granting him an approval. 308 says, when he has to give evidence against the accused, the second time during court, he does not give the evidence as he had undertaken to do so. Then the order of pardon can be withdrawn. And there are two aspects which can happen to him. One, he has to be separately tried for the actual offense, independently tried for the actual offense. And second, he has to be tried for false evidence. And for false evidence, I will come to one strange fact which the CRPC had said. they give a proviso under section 308. They say, provided, they gave two provisos. If you see 308, later on you can have a look at it. As I said, I keep wondering whether I am here as a preaching. I am not. Provided that one is, such person shall not be tried jointly with the other accused. But second one is important, which advocates skip over. Provided further that such person shall not be tried for the offense of giving false evidence, that is, inviting the court to give him a pardon, except with the sanction of the High Court. Now, where does this compare with the sanction under Prevention of Corruption Act? Under Prevention of Corruption Act, you also have the word sanction. No court shall take cognizance of any offense unless there is sanction. Now, under Prevention of Corruption Act, the sanctioning authority is a disciplinary authority or somebody who has control over that accused future. He can pass a disciplinary order against that particular accused. So he has to give a sanction before the final report is filed. The sanction order has to be put in, and then only when that sanction order is there, the court can take cognizance. But here, let us take for example an approver who is a contract killer. The High Court has nothing to do with him. The High Court is not required to give sanction to him. He is not a disciplinary authority over him. The High Court has neither the disciplinary authority nor the appointing authority, nothing. But still, sanction of the High Court. Now, when as an advocate, have any one of you thought, should this sanction, if you read Prevention of Corruption Act sanction, and if it is, let me take the very base example of a disciplinary authority who reads the papers and signs. You can call that sanctioning authority and cross-examine him. You have a right. But High Court, should it be on the administrative side of the High Court or should it be a judicial order of the High Court? That is a question. This is where advocates should examine each word of any particular section. If it is an administrative order of the High Court, then the High Court is represented by the Registrar General. He's a face, any letter of the High Court is issued in the name of the Registrar General. Can you summon the Registrar General and ask him, have you examined all the papers relating to grant of pardon, the papers relating to the evidence which made the Chief Judicial Magistrate to give pardon, the evidence which the satisfaction of the police official to first say that this person is going to be an approver? Are you going to cross-examine the Registrar General? It is, or should it be a judicial order? No person can be so prosecuted except with a certificate of the public prosecutor. That is another aspect. Now, this certificate of the public prosecutor, he is also the prosecutor. He also is the person who says commit him to trial. He does that double role. If you see any final report filed in any court, it is filed not by the public prosecutor who appears before you. He may be there, but it is countersigned by the director or somebody of the prosecutions who vets that particular final order, or signed by the inspector, not by the prosecutor who appears before you. Here it is double role. He certifies that this person must be prosecuted and then forwards it. Now, what does the High Court should do? Should it give it on the administrative side or should it give it on the judicial side? This question has not yet been thoroughly exploited at any point of time. There have been instances where Kerala High Court and Madhya Pradesh High Court and Punjab and Haryana High Court have refused to give sanction on a criminal OP filed by the prosecutor. Have refused. They said, no, it is not us. Then who is to give? This is what is linguistic. Language is all about when you analyze evidence. So at every point of time, behind every statement, you have to correlate the provision the language used by the witness and how as advocates you are going to handle that particular language, sometimes spoken, sometimes just crying, like Alavandar's wife who just stood and cried. Nothing else. She just saw the body and she cried. How much can we cross-examine that lady then? What about his character? What about his conduct? What about where he went? How can you say because she cried, these two persons committed the murder? The fact is that it is not about that. The fact is about the murder which happened. That is the central issue which has to be examined. That is what has to be proved by the prosecution. And where did that proof go away? By this witness who simply cried. These are aspects which I think should kindle a thought process in each one of you. Now, the aspect of proof beyond reasonable doubt. Now, that is also a question. Now, what actually is proof? Why should it be proved beyond? Now, it is not anywhere in any of our literature, in any of our legislations, that the prosecution must prove beyond reasonable doubt. It is a principle laid down by law. It's old Wilmington principle. And that came about in a strange manner. In England, long back, they said on Sundays, nobody should go watch a movie, particularly with a young child. The lady went with a young child and then was prosecuted. Proof beyond reasonable doubt that you actually took this child who was younger than this age and therefore saw a movie and therefore you're accused. That has been imported to our judicial principle as proof beyond reasonable doubt, to be offset with preponderance of probabilities which only depend on whether that particular fact is conclusively proved or whether the court shall presume or may presume. These are few aspects on evidence which depends on purely language involved. That is why this topic on linguistic experience. There are, if you analyze any provision, you will be coming around and around to this. I would therefore request, my experience, when I joined law college, I had the fortune of being associated with a trial court advocate in Georgetown Court, Madras Georgetown Court. His name was Rangavajula Krishnamurthy, very famous advocate. He made a lot of money by going to just Georgetown Court. He purchased 4 houses, 2 or 3 cars, everything. Wonderful at cross-examination. But the nature of training was to go every day. One of the bases opposite Georgetown Court, you have the Burma Bazaar. So at that time, even a television set was smuggled, a watch was smuggled, everything was smuggled. We never had, I'm talking about 86, 87, 88. During my period in 86 October onwards, so 87, 88, 89. During my period in law college. He had a clerk who had an independent practice. So he had 1 or 2 advocates under the clerk. So those small young advocates, I was only a law student. So they thought that I can be useful. And practically every other day there will be a raid by the customs in the Burma Bazaar shop. You all would have known the Burma Bazaar shop. But what you may know or may not know is that there is a small window behind every shop which leads to the railway track. So somebody can jump over there. If there is a raid by the customs at the first shop, news will spread and here they will put it out. And there is a hole on top. So you can climb on top and hide behind on the roof. This is practical. And whenever this is done, the accused will be brought to the court for remand at 3:30 in the afternoon the next day. It happens in every magistrate court. In the afternoon they are brought for normal remand, 24 hours. At 9:30 in the morning, the customs or the police officials will come with the list of accused whom they are going to bring at 3:30 and give it to the court bench clerk. I was assigned 16th Court Hall. That is what Roypuram, Kashimad and Washermanpet, where I lived. So at 9:30, as a law college student, I have to stand in front of the court hall. And whenever the policeman comes, I got to get that particular piece of paper with the details of the accused and take a cycle and run down to the junior of the senior advocate who will have just 2 or 3 years experience, and he will type some bail application, always innocent, a very respectful person, all that. At 3:30, file it before the magistrate court. If bail is granted, all 3 of us will share 15 rupees. This experience of practically going to magistrate's court for 1.5 years, seeing all those accused moving and understanding, now this gives a strong base in procedural law. Later, when joined the senior, as he said, Mr. V.S. Subramaniam, it was a different thing, but still procedure. It was only about office of the court knowing how to draft a prayer. That we will have to learn only from the staff. And typing and presenting and that background work. That helps everybody. And that is why I always feel that this sort of an experience will actually help every one of you. Now let me tell you one small secret and then I will stop. I think I'm not involved in it, and even if I am, I do not think I shall be directly involved, because it is considered that I am not junior enough to be considered as a senior judge, not senior enough to be trusted as a junior judge, because if you ask questions, then you're not comfortable. But as advocates, here in Madurai, when I was there for 3 years, 2009 there was an exam for civil judges junior division. You were there. I was there as second additional district judge. I used to take classes in the Madurai and for all the advocates, and we were all very happy because 25 advocates, highest number of all the districts, were selected from Madurai District Court for the 2009 exam. One small hint alone I will give. I am not directly involved in any of the exam related aspects, so therefore with a clear conscience I can say, if anybody is writing for direct district judge exam, or if anybody is writing for civil judge junior division exam, CPC and CRPC are divisible into 2 separate parts. CRPC deals one half only with respect to procedures in magistrate courts, the other half with procedures relating to sessions courts. CPC deals with one half relating to trial of cases. The second half relates to appeal of cases, first appeal out of 41 and all that. If you understand that division, you'll be able to focus yourself as to what to study and what to prepare for each exam. So that is one thing, because generally it is felt that we have to learn a lot, but it is not so. And unless you know the procedure, it is not going to be, it is going to be very difficult. Now what else? I think I've held you, all of you, up for a considerable period of time. It is 6:40 and I know your work starts now. 8:30 onwards, all of you will be quite busy in your offices. So let me wind up here, and I hope it had been a little useful in all this. This may not have directly what you expected as linguistic evidence, but with my limited knowledge I wanted to convey only this, that language in the legislature is very, very important, and every word has to be independently examined. I would thank everybody for patient hearing. I hope that you don't go out and saying but anyway. And I also know that, as I've been like all of you, when judge speaks, everybody has to listen, and it is not that. And to a little extent, I was quite surprised that I was invited. I've never been, very rarely been invited. I've never been invited here to this hall at all, and therefore very, very surprised when Mr. Srinivasa Raghavan came and gave me, and I had a lot of doubt, should I or should I not, and I had no option because they all sat there in front of me, and I had no option. I had to say yes, and then I had to look wise. And I hoped that none of you think, is it contempt, is a judge, do you think I am a fool? That's what the question was actually. And he said yes. If he says yes, it is contempt of court. If he says no, it is perjury. So I stand in between that. And thank you very much. And I wish all of you the very best in your career. Thank you.
Thank you so much, Lordship. On and off the dais, our Lordship is a mesmerizer, not just with his intellect, but also with the acoustic of his voice. We are a true mesmerizer of your voice, Lordship. When our Lordship took the podium, he asked 4 questions between hard working and hardly working and wise or otherwise. We are not aware of all that, but one thing we are very sure, Lordship. Our Lordship is the one who doesn't work for fashion, but with passion. Thank you, Lordship. May I now request Mr. ATHIFF, Mahaboob ATHIFF, to give the thanks note.
My Lord Justice C.V. Karthikeyan, Mr. Srinivasa, Raghavan, the President of the Bar Association, and Vice President Mr. K.P. Narayana Kumar, Senior Advocate and former Additional Advocate General Sri Charan, and Senior Advocate Sri Balasundaram sir, other members of the bar, my Chairman Sri Professor GNANASEKARAN sir, and my colleagues in the committee, Mr. Iram Kumar, who had joined us and also had taken care of the refreshment, and other members of the bar, my friends. I was asked to give the vote of thanks, and I've still not come to grip with after hearing that brilliant lecture. In fact, there were a lot of people who kept asking me as I was sending the invitations to everybody as to what is linguistic evidence. And having known, at least for me, having seen and having practiced before His Lordships, I know that His Lordships always used to see things very differently. And one can recollect the words of Robert Frost, that he took the one less traveled by and that had always made a difference. Lordships was speaking about wise judges and who are otherwise, but I can always say your Lordships have always been the original thinker. When I'm a lawyer, I'm supposed to substantiate what one says. And I would say one small anecdote there was a very important case regarding when His Lordship sat on last occasion here in the writ portfolio. And there were 2 senior advocates who appeared in the matter where it was regarding implementation of a UGC regulation to state universities. And arguments went on for days together. But when the order came, it was a very short order. But the most beautiful thing was a view was taken that surprised everybody, which was completely perfect. So it was an original thinking that always marks His Lordships, and therefore this is no exception. It's been the same way. So I thank my lords for which we could see the experience that His Lordships had from the days of his student days into the bar and in the bench, and all that compacted and given to us in this lecture. So thank you, my lords, for the electrifying lecture. And the fact that we all remained silent in an evening despite full days of work with rapt attention would testify that. And I would also like to thank our president, who always led us in this and who had taken us forward in every lecture that we organized, who always accompanied us despite he used to say that my eyesight is failing and other things, but he always stood with us and led us as a team, and all my team members who organized it so beautifully well. We also like to thank Mr. Iram Kumar, who volunteered to help us in this, because we usually have very little time to organize everything. So thank you, sir. And at last, thank all of you for today the hall is full. Most of the times I've seen sometimes people just walk away halfway through, but today we had a packed and rapt, attentive audience. So thanks for all of you for being here. And MMBA has always stood with each of the committees to make every program successful, and particularly SSR sir and K.P. Narayana Kumar sir, who had always supported us in this. And in fact, when we were thinking of whom to invite, and in fact, we decided to have, and then both of us had a discussion, and we decided that we will even postpone the function because we were told that His Lordships will be coming here. So we are absolutely not we are happy that we took that decision, and I thank all of you again, and we hope that we will give you more such interesting and insightful programs. Thank you.
Thank you, sir.